And once again, welcome and thanks for joining today's session, How Probate Cash Can Help with Cash Flow Without the Cost to the Attorneys, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. The presenters will address questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat, and someone will respond separately after the presentation. Our presenters today are professionals with extensive experience in the probate field. Marc Harris is an attorney admitted to the Florida Bar in Southern District of Florida. Marc is also a member of Florida's Bar's Real Property, Probate, and Trust Law section. Marc has been working in the specialty finance industry for 25 years, involved in purchasing over $100 million of assets. Many of the purchases, pursuant to various state laws, required court hearings, many of which Marc has either attended or appeared as counsel. As CEO of ProbateCash, Marc is now spearheading a relatively new industry of purchasing interest in active pending inheritance claims from estates or trust. We also have Matt S. Dana, who's a JD, LLM, CPA, NCLU, and he began his legal career in Mesa, Arizona in 1984 after graduating from ASU Law School. And during his prestigious career, he's founded Dana and Associates, Inc., which later became Dana Law Firm, focusing his practice to estate planning. And 6 years ago, he established another law firm, Dana Whiting Law. And 6 years in, and Dana Whiting Law has seen remarkable growth and expansion throughout Arizona and California. Since the firm has attorneys licensed in nearly 20 different states, Matt is now seeing clients all over the country. And so now, without further ado, let's hear from Marc and Matt.
Thanks, Molly. Good afternoon or good morning, everyone, depending on where you are in the country. See, we have a good amount of people on, mostly attorneys, but other professionals as well. So ProbateCash is a company that was founded to advance beneficiaries of estates money against their inheritance. So we know that their inheritance is tied up in probate. Many beneficiaries don't understand the probate process and need money now. They can't wait for their inheritance. I'm sure a lot of folks on this call have been there. They field a whole bunch of phone calls from beneficiaries, executors, whomever it may be. So when do I get my inheritance? When does this whole this thing called probate wrap up? We are filling that hole, and we are able to advance that money. We wait until the assets are distributed. We can get paid back anytime, but usually it's when the assets are distributed from the estate. And most importantly, probably to beneficiaries, our company provides these advances, which are non-recourse. And so if there are claims that wipe out a beneficiary's interest in an estate, or if there's a change in heirship, a challenge to the will, and there's not enough money to pay us back, we don't get paid back. Our contracts are only with the beneficiary who's receiving the money. So if there is a shortfall, we do not look to other beneficiaries to get repaid. We don't look to the estate. It doesn't hold, our advances also do not have any delays, cause any delays to the estate administration being done. So that's the quicker or rambling introduction of what ProbateCash does. And I'm happy to have Matt Dana with us from Dana Whiting Firm out of Scottsdale, Arizona. Matt, why don't you've used our services before, I think, and with your firm, how has that helped your clients?
Yeah, thanks, Marc, and Molly. Thanks for that introduction. Very, very kind. And you missed a few initials there, but I'll forgive you for that. But anyway,
there are a lot of initials.
Yeah, there. I'm an old war dog. Been practicing for 39 years. It'll be 40 years next year, and I've always done probate and estate planning both. And I kind of grew up, to be a tax attorney and loved estate planning, and evolved the last few years into probate, and kind of like that a lot better than estate planning for a lot of reasons. And I want people to understand I'm just like them. I'm out there in the trenches trying to figure out how to grow a practice, and how to convert probate into cash and revenue streams. And I didn't really know about ProbateCash, Marc, and as you know, until maybe 6 months ago or a year ago. I'd heard about companies out there that are starting to finance probate, and I was always intrigued with the concept. And I think I met you guys through, I think you actually bought a beneficial interest of one of our clients, and that's where I initially heard about you and reached out. And I will tell our listeners that I think the relationship that I've established with ProbateCash is changing my probate practice in many different ways that we're seeing growth from it. And being the old war dog and being the managing partner and interested in revenue streams, I realize that if we made it easier for our clients to finance the retainer, then that's going to help us with our cash flow. And I think I told you, Mark, initially that we used to take some probates, and the main asset was a house or a piece of real estate that might take some time to sell. And we knew that we'd get paid sooner or later, and we would defer our fees until the house was sold. And that created a lot of cash flow problems, especially if the house, went into different problems where you're in a down market, it's tough to sell, or there's some kind of a family dispute on how much to sell it for. And so I was really glad when I found out you guys offer this option where you could actually, loan money to the estate to finance legal fees. And I think that's, I think as probate attorneys, we get that message out to potential clients. I think it'll help attract clients to you. And then the other thing is, you've talked about how you guys will actually buy out the beneficial's interest in an estate, and that's quite different from a loan. That isn't a loan, and you're actually helping those beneficiaries with their cash flow problems they have today. Even though they know they're going to get some kind of an inheritance in the future. I know we worked with you guys on a case that didn't end up panning out for a lot of different reasons, but at the moment that our client died and the estate went into probate, he had a son that the house was actually in foreclosure, and there was like a 30-day fuse on that guy was going to lose his house. And it didn't matter that in this particular estate, I don't know, Mark, if you remember the facts, but this guy's share of the inheritance was going to be $2 or $3 million. It was sizable, but that this expected inheritance isn't going to be enough to stop the foreclosure. And anybody out there that's practicing the probate space, when people call in, they may not ask directly, but they have two questions. How much am I going to get, and when am I going to get it? And it's not necessarily that they're greedy. It's they've got huge financial problems of their own, and they're just trying to solve that problem. But I would suggest, Mark, that's kind of a long answer, but that's been my experience, how it's changed my practice in two profound ways.
Yeah, so thanks for that. I want to go through a little bit of the process of how that works, because you're on the receiving end of either getting a upfront retainer fee. So in that situation, I know a lot of you on this call and throughout run your practice through marketing dollars that include search engine, mailers, and other forms of marketing. And when you're getting calls for new clients, a lot of them cannot afford to pay probate. In fact, we know how a lot of people come to probate lawyers. They go to the bank to access the decedent's bank account, and the banker says, hey, do you have the letters testamentary? What are you talking about? You need to go see a probate attorney. They try to list the sale of the home. They try to sell the estate home, and they can't list it or enter into an agreement with a broker because they don't have the letters. And so what's the first phone call they then make? All right, they're going to call you guys. How are they going to find you? They're going to find you however you market. And then when you say, okay, my retainer is $5,000 and or whatever it may be, they say, well, I don't have the money. And then you're turning them down. A lot of you are turning them down, or you are going to go ahead and front the money, which can cause cash flow problems. Where we come in to say, okay, meet with them. If they have assets that are going to be sold through the estate, such as the house, there is money in the bank account that aren't going to beneficiaries, but going through the estate. And we know their assets, we'll advance the person money will be in contract privity with that beneficiary, potential beneficiary. They'll direct us to pay you guys the money for the retainer fee. And then when the estate is finally ready to the assets are to be distributed, we get paid back. We'll get paid back the advance plus our fee. The beneficiary who wrote that check to you guys or is paying us back, that's an expense to the estate. So that person won't be stuck with it. And that's how we proceed. And in the other scenario where we are buying out the interest of the inheritance, or first off, we never buy out the person's entire inheritance. We absolutely want every beneficiary to have skin in the game throughout the entire process. So we'll only buy a portion of the inheritance through each stage. So we'll get in, as if we're getting into advancing fees, obviously we're getting into the game well before the claims period ends, before there's an inventory filed. We're getting in pretty early. So that's our business, that's our risk. We know that. What we do is the beneficiary will sign an affidavit with an assignment of the inheritance. What we do is we file the assignment of the inheritance with the probate court. So all these transactions are incredibly transparent. Now, not our contract, but just the assignment inheritance. So the assignment of the inheritance. So if somebody's assigning $20,000 of their inheritance, it's on record. Everybody who is a party to the probate case is going to get that assignment. And the personal representative will know that a beneficiary, it could be the personal representative too, has assigned that $20,000 to ProbateCash. And so when the assets are to be distributed, ProbateCash will get paid the $20,000 from the personal representative. There is, in fact, a state statute in California right on this point. And so assignments of inheritances are done in California pursuant to a state statute. It's been that way now for several years, for over 10 years in California, and we follow that to a T. We use that statute, follow it in spirit, to the letter, basically, in all the other states we do business. So we do business in all 50 states around the country, and we use the California statute as the model because California is the only state right now that has a statute governing these assignments. So that's the process. And again, as lawyers, you also should know that an assignment to a beneficiary is not going to slow down the process. And there's no liability on you as lawyers. There's no liability on the personal representative. And one assignment to a beneficiary has no adverse effect whatsoever on the other beneficiaries. So these are very clean, transparent transactions that help a beneficiary open up a probate case by paying attorney's fees. Other ways, Matt, I'm sure you've seen, as you're talking about the house, we've seen instances where beneficiaries need cash so badly that they're willing to take a below market offer for their house. And, you know, that's always going to be available. There are always going to be people who will provide cash for homes. But what we can do is advance money to the estate, to a beneficiary, to use that money to put repairs in the house. $20,000 of fixing up a home could mean a resale value, $50, $60, $100,000. And that's going to benefit all the beneficiaries. And so ProbateCash has always basically branded itself in a way as having another tool in your probate toolbox. And so many people don't know about what we do, what service we have and how it helps them. I think it's very important for lawyers, realtors, for all sorts of folks to know about what we do, because you can offer that to beneficiaries. So when they're calling you up and saying, when am I going to get paid? As Matt said, you know, how much and when, especially when, you can say, again, you know, it's going to be some time before the probate wraps up, but if you really need the money badly enough, I have somebody to call. That takes the pressure off of your office, takes the pressure off the executor, and gets money in the pockets of the beneficiary that needs it.
Mark, let me jump in on that idea.
Sure.
When do I get paid type thing. So, sometimes, when we get these calls, they want to know what our fees are, right? And, how much it's going to cost and when they have to pay us and these kinds of issues. And just as a selling point, I generally say our fees are going to be about the same as your fees, and I need to let them understand that, you know, the caller, if they're going to be the executor, they're entitled to fees as well, and I don't think they recognize that. And so it's easier to sell my fee when I sell their fee at the same time, and say they're going to probably be pretty close, and the more you do, the less I have to do, and that type of thing. And then, you know, then you could talk about not only financing, you know, not only financing, you know, a retainer for legal fees, but maybe financing, you know, payment to them as the personal representative for their services.
That's that's a very good point too, and it's the same. And we will advance, even though that's not really their inheritance. We will advance against the personal representative's fees, you know, so whether they're beneficiary or not.
Well, yeah, and you know, you'll advance for any fee, right? You talk about the fees to fix up the house, or the fees to pay the attorney, or there could be fees to the CPA, or, you know, fees to the personal representative. So I'm just saying it as a selling point. I found that very helpful when they're asking about my fees. I turn around and talk about their fees, and then how we can both get paid. Now we're partners.
Yeah, that's a great point for everyone who's listening here, because I mean, this is definitely one big part of what we do is as we've said, is help folks market. We've all been there, and one of the worst things you can do is turn down new business because somebody doesn't have the money to pay up front, and you don't want to front the case.
Yeah. Mark, let me talk about one other area where I've seen value, you know, working with ProbateCash is, you know, we've always been first and foremost, you know, estate planning and probate lawyers. And as anybody out there knows, you're going to get a lot of calls from the beneficiary that's not the executor. And Mark, you remember when, you know, Dana Whiting Law, we used to turn down those cases. And in fact, I used to openly say we only represent executors in our marketing material. And then I recognize what a huge mistake that is, because I would just guess that probably, you know, 40 to 50% of all of our callers are the beneficiaries. And there could be a real opportunity there. And so what I did with our firm is we partnered up with some estate litigation firms. And, you know, certainly it's always fair and reasonable for attorneys to share legal fees as long as it's disclosed to the client. But instead of turning down these estate litigation cases, I turn them over to our estate litigation partners. And then, you know, these could be very good cases where that person that is going to litigate the estate, they need cash in the meantime, that there again, ProbateCash can help them.
And that's a good point. So what we've been talking about are money up front to open up the probate. We've been talking about purchasing a portion of the inheritance. What we didn't touch on, and you're right, we also have set aside resources to advance money to purchase basically an interest in the case of a litigation case. And I think people have pretty much by now heard of pre-settlement litigation funding, pre-settlement funding. So plaintiffs of a personal injury case, or, you know, some kind of tort case, have a pending case, and companies will advance those people money against their eventual settlement, usually, but potentially a verdict. We do that in the probate space, and no one really does that in the probate space. So you have somebody coming in and they're challenging a will, or a will is being challenged, but or some other issue potentially, and there's going to be a fight. There's going to be litigation. That litigation can take, as we all know, years. And that is something that we also will get into. So, and those can be done very confidentially. So understanding that some of you, if you are in litigation, you don't want the other side to know that your client is receiving money right now to get through the litigation. And so we can provide those kind of advances as well.
Yeah, Mark, I would tell our listeners that, just from my experience, when I'm talking to these estate litigators and partnering up with them, kind of our normal fee share is 20% if we're not really involved, just, you know, kind of handing off the case. but 50% if the case is big enough and we're going to need to stay involved, because a lot of these estate litigators, they don't really understand the nuances of wills and trust and the estate planning, and they really need an estate lawyer as kind of their professional advisor. And so I guess the point I want to make is everybody on this call knows the money we can make as probate lawyers collecting legal fees, handling the probate, but now start focusing on another revenue stream on the litigation you've been turning down. And you know, not to brag or anything, but we had a case where our share of the estate litigation was you know, $1 million. And so, you know, most of the calls you're going to get are going to be garbage and small, and you're not going to want to take them. But there's some gems out there that, you know, if you're willing to go through the weeds for a little while, that could be a real profitable practice area.
Yeah.
You guys have touched on so many great things. I don't want to interrupt, but we're already a little past the 20 minutes, and I want to make sure we get questions and we don't run over any time too much, and you guys might have more thoughts with the questions. So I just want to remind everyone, if you have to leave, we'll be sending a link to the recording of the presentation and questions and answers. I think one of the first questions is, what is the timeline to get a probate advance?
Yeah, somebody calls you up and says, I want to get how do I get an advance? They call our office, they fill out an application. We can turn around the request anywhere from 1 business day to usually 3 business days, depending on where the case is, depending on the cooperation also of the estate attorney. The estate attorney provides us with insight to the case, and we feel good about the advance. That can be a very quick turnaround. If we're doing our own underwriting without the estate attorney's cooperation, and we're just looking at what's in the public records, we're interpreting that, it could take more than 1 day. But we know that people are calling us because they need money. The turnaround is incredibly quick. We have a bunch of underwriters here. They're all paralegals with probate experience, and have some of counsel in different states as well to review some of the trickier cases. We turn it around pretty quickly.
Kind of adding to that, is there a finance charge, or is this a flat fee? I know that's always something on people's minds.
Sure. So yeah, I imagine so. So these are non-recourse advances, as I said. These are not loans. They don't have characteristics of loans. We do not do a credit check. We don't charge an interest rate. There's no late fees or anything like that. These are non-recourse advances, and we charge fees. So we charge a fee every quarter. These are not cheap advances, as you can imagine. These are for folks who don't have the ability to get money elsewhere. So if somebody had the ability to refinance a home, if they had the ability to get money from their brother-in-law, something like that, they should. I mean, and that's okay. I don't mind saying that. So we do charge a fee, and the risk basically, or the fee amount will reflect the risk. If we get more cooperation from the estate attorney and our risk is less, then our fees will be less. We're very transparent with those in the contracts. And also one other thing, I think some lawyers do have a concern, if they make referrals, do they have any liability? First off, no, I don't think I have any liability. Second, what we do, besides somebody signing our contracts, we then have a recorded call with our customer, and we go through the terms of the contract, make sure they understand the contract, what the payback amount is going to be, depending on when it's going to be paid. And we save those recorded calls. And we of course let them know the call is being recorded, and we have that as well. So we're very careful on our side. As you had indicated in the introduction, I'm an attorney. My wife is an attorney. She has her own practice. I know it's very important to, 1, make the lawyer look good, and 2, make sure that the lawyer has total confidence in referring folks to our company.
Well, that's good to know. And I think we got most of the questions, but I know I kind of cut you guys off. So I want to let you guys have a moment if there's any final thoughts you want to share before we wrap things up here.
Molly, I want to make sure if everyone has our contact information.
Yes,
It
I
may
was
be
going to
something
send that
that-
at the end. I was going to read them off to you, but like I said, I knew I kind of jumped in there. I want to make sure you guys got all your valuable points in there. So
And you couldn't get two more people that could talk forever than me and Matt probably on this stuff, but
great.
but this is important that
But-
everyone know about what we do, because I think a lot of the biggest issue with our business is people don't know we exist, and how it could then, the fact we do exist, how it can help your practice.
So that's exactly. And I think we got everyone's questions, but if you're like me and you think of it 30 minutes later, we will be sending up a follow-up email with an e-brochure for ProbateCash and a link to this webinar. And like Mark said, I want to get you guys their contact information. So you can call Mark at 561-476-0018, or you can email him at Marc, and it's MARC, at probatecash.com. You can also contact Matt by calling him at 480-515-3716. You can email him, and it's a little bit longer of an email, so get your pencils ready.
Let me give you the short version of that, Molly. It's I got a
perfect.
short version of it. It's Matt,
Perfect.
MATT.Dana, DANA, at DWL, Delta Whiskey Lima, DWLAZ.com.
Perfect. That made my job a lot easier.
There you
So
go.
thank you guys again. Thank you everyone for joining us, and I hope everyone has a great day.
Thank
Thanks.
you, guys.